This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. I'm Stuart Address, and this is Ask a Lawyer. I hope you've all had a week without involvement from attorneys. They're usually not pleasant. I hope you haven't needed an attorney. But if you have any questions...
You're just so warm and fuzzy.
I am. I try to be. But I can also be very scary. I've got a statue in my conference room, from Disney. It's a big statue of Grumpy. And I can get very grumpy. Doesn't take much. Anyway, if you happen to be involved with an attorney or being threatened by an attorney or thinking you might have some legal issue, feel free to call us here at 340-1590. I'd be happy to answer your questions. We also have, as I mentioned last week, I have a new paralegal in my office. Her name is Sadia, Saiidia, as she likes to say, pronounced like Nadia. And you can give her a call at 781-8003. I'm sure she'd be happy to hear from you. She comes to us from 6 years with judges. 4 years in the 15th Judicial Circuit, which is in Palm Beach County, and then 2 years with a federal judge in the Southern District of Florida. So she comes from the other side of the bench.
Okay, where is the Southern District of Florida? Is that
from
Miami?
From Key West all the way up through Indian River County.
Really?
And maybe
all that is one district?
Yes, maybe a little bit beyond. I don't know where the middle district starts.
Holy smokes, that's huge.
Well, we have the Southern District, we have the Middle District, and the Northern District. So, they're big districts.
Okay, you say Key West, but I mean, there's no courthouse down there, is there?
There is a courthouse. Well, there is I don't know if there's a federal courthouse. They use probably Miami. But it goes all the way down to that little thing that says Cuba 60 miles.
Oh, wow. Okay. Oh, okay. Huh.
Anyway.
Coming soon, courtroom in Havana. Oh,
that's right. Hey,
when we annex Cuba. Oh.
No habla español. Cliff reminds me of stories. You remind me of stories. I had an opportunity once to go to Havana to represent an American who was on trial and was most likely going to get the death penalty for allegedly being a spy.
Whoa!
And our goal was to try to get him life imprisonment. Now, this was when I was working for my former law firm, and the Cuban government, obviously Fidel Castro, asked that we submit 3 passports for approval. So we submitted mine, the gentleman who owned the firm, Guy Rubin, and his father's, Ellis Rubin, who was a very famous criminal defense attorney.
Oh,
and a 4th.
So you were with Rubin and Rubin,
Yes,
huh?
I was.
Whoa!
And we submitted a 4th passport. That last name is going to escape me now. But he's up in Orlando, and he was a former judge. And the Cuban government approved 1 passport for the gentleman up in Orlando, Dominic Salfo. And he got to go to Havana and sit in on this trial. He was not allowed to consult with his client before trial. Remember, this is Cuba. He was not allowed to speak to his client during trial.
Come on.
The client had a Cuban attorney assigned.
Why was he even there?
He was able to speak to the Cuban attorney.
Oh, boy.
And they did enter a life sentence, which was a lot better than a death sentence. So apparently the American pressure, the family who got Rubin involved, and the publicity of having a former judge, Dominic Salfi, in Havana, observing the trial, was enough, I think, to get them to say life in prison for this alleged spy. Now, I don't know what's happened since then. I don't know whether maybe he was released or what have you. This was probably a good 15, 18 years ago.
Wow. Okay.
But when we were submitting the passports, and I was thinking, gee, I may be going to Havana. One part of me was excited, the whole idea.
Oh, yeah, that would be so cool.
The other part of me, for those of you who listen to me regularly, was thinking, what am I going to eat? I don't think they have McDonald's. I don't think they have Pizza Hut. I wasn't quite sure how I would manage eating.
Better stuff. It's all natural Cuban food.
Yeah,
man.
Remember,
I
just went through an eating disorder clinic, still working at it. I'm not quite sure what I would have done there. Anyway, so that was an interesting story. Talk about, what you just raised. And then Cliff says, in his Swap Shop show, he's talking about me scaring people with letters. And that's a great little lead-in, and it's fun. And the reality is when I write demand letters, I try to write long, nasty, scary letters because they're the only ones that are really designed to get impact.
And besides, you're paid by the word.
I get a bonus over 10,000 words.
That's right.
So there was about, 15 years ago, I had a federal sexual harassment case here in the Southern District of Florida. And there was an attorney representing the employer, a local attorney. I think he was actually in Port St. Lucie. And I would send a discovery request. He wouldn't answer it. I'd file a motion to compel. It would be granted. He still wouldn't respond. I'd file a motion for sanctions. It would be granted. Maybe I'd get a response. I don't remember. But this happened like 6 times. Motion didn't get an answer. Motion to compel, granted. Motion for sanctions, granted. Finally, I asked...
Now, how long a period of time is this going on?
Oh, this is going over about a year.
Oh, my God.
So finally, I asked for what's called the death sanction. I asked them to strike his client's pleadings and enter judgment in my client's favor.
Yeah.
The rules say that is the last straw for a federal judge, only when nothing else works. Okay? Because sometimes you're punishing the party for the client, for the attorney's problems, as would have turned out to be in this case. So the federal magistrate judge in Fort Pierce at that time, Frank Lynch, calls us into for a hearing on my most recent motion to strike the pleadings and for sanctions. And I make my argument. We've had 5, 6, 7 motions, Judge.
Yeah.
You keep entering orders. You keep upping the attorney's fees. Nothing is working. And here comes a question. We'll get back to the end of the story. Like Paul Harvey used to say, the more about the end of the story after these messages or this question. We have Judy on line 3. Hello, Judy.
Hello. Can you hear me now?
I can hear you, and if you haven't seen the recent movie, may I just say, Judy, Judy, Judy.
It's been around for years.
How can I help you?
I have a question on commissioned employees.
What employee?
A commissioned?
Judy, are you on a speakerphone? Because it is really low.
All right, a commissioned employee.
Yeah, hold on here.
All right.
I think she's on either speaker or Bluetooth.
Okay, you can hear me better?
Much better.
As they say on the Sprint, I can hear you now.
Yeah, you took it off Bluetooth or something. Yeah, you got it.
Hard for me to hear you then.
Oh, now it's hard for you to hear me. Well, I have a loud voice.
Oh, good. Yeah, a commissioned employee, somebody who gets paid by commission, but yet they're not a salesperson.
Okay.
How do you find out what your rights are as an employee concerning that factor?
Well, I'm not sure what rights are you talking about.
Well, I mean, you are given, let's say you are given a route. Okay, it's the employer's customer.
Okay.
You are given an area to go do. They hand you what you need to go do.
Okay.
You personally do not collect payment when you're there. It's a job that gets done without generally contacting the homeowner.
Right.
Unless they happen to be home and you talk to them.
Okay.
But you don't get paid until the customer pays.
Okay, that's pretty standard.
On the employer billing, etc. And you're considered to be available for that service that you do from 7 to 5 every day.
Okay.
Or be on call if you're not out there working, whatever. Be available to. What do you do with they want you to cover extra hours on, say, a weekend or a night, and it's not for any customers that you personally get paid for?
Well, now it depends upon whether or not you are an employee or an independent contractor. And it also depends. Okay. And then it depends upon whether you fall within an exemption to overtime for the Fair Labor Standards Act. If you are non-exempt, because let's say I'd be looking here at the outside salesperson exemption. If you are exempt, then they can make you work as much as they want under the compensation agreement they've agreed to with you, which is commission. If you are non-exempt, then you have to be paid at least the minimum wage for all the hours that you work and overtime for anything over 40. Now, they're allowed to utilize those commissions to reach that amount, that minimum wage, and that overtime. So it gets a little bit complicated in calculation. But the first significant question for me ends up being whether or not you are exempt. If you are an outside salesperson, you are very likely exempt from overtime, which means that they can basically tell you to cover whatever geographical area they want, whatever time they want, and give you the commissions that you've negotiated. And if you're not happy, you certainly are free to leave.
Correct. But we are a service employee. We are not a sales.
Okay, so you're service, not sales.
We could do sales if we would want to, and sometimes you have somebody walk up and say, hey, what would you charge?
All right, but that's not your primary job. If you're a service employee, then I would think off the bat that you are probably non-exempt and entitled to be paid hourly for all the hours you work and overtime for any hours over 40. And you can deduct commissions from that calculation.
So if they had her work, say, 80 hours a week,
right,
they'd have to pay her 40 hours of overtime.
That is correct. And then if she's made $100,000 that week in commissions.
Congratulations, Judy.
Then they're not going to.
Really, I'm doing well.
Then they're not going to have to pay her anything, obviously. But if she's made $500 in commissions, they probably are going to owe her money.
Okay.
Like I said, the main question was, just the factor, too, of I'll go out and do the service, turn in the paperwork saying it's done, completed, etc. And I receive commission from this month, basically next month. So whatever comes in from what I've done, by the end of the month, they pay me on the 15th of next month.
Right. My father was a Whoa! I think that's a nuclear alarm.
I guess.
My father was a commission salesperson for half a century.
If a customer did not pay their bill,
you didn't get paid.
I don't get paid for it.
Right. That's very common with commissioned salespeople. Now, service, I don't know if that's kosher. I would have to look into that a little bit more.
Yeah, that's the question for me, because I've been doing this for a number of years, and there's a number.
Where are you? Where do you live? Where are you located?
Stuart.
All right. Let me suggest honestly, give Sadia a call, and give her a little bit more of the facts that she can spend more time with you on the phone, and then she'll discuss it with me, and we'll see maybe whether or not you have a viable claim for wages.
Yeah, well, like I said, if nothing else, when I retire, I'd like to make things better for the next people.
I hear you, and that's all. That's a great, altruistic goal. That's always good. So
Yeah.
if you want, give us a call at 781-8003. And thank you for calling.
Thank you very much.
Take care.
Well, the old thing in radio sales is, it's not sold until it's paid for.
Well, and that's pretty common that you don't get paid until the employer receives the money. So, that is, there's law on that's perfectly okay.
But now, wait a minute. She's not doing sales.
No, she's not.
Service.
She's doing service, and that leads me to my first instinct is that she's entitled to be paid at least a minimum wage plus overtime. From that, her commissions could be deducted from that to see whether or not they owe her any money. Now, like I said, there are 200 exemptions. There's 3 that account for like 90% of all FLSA cases, Fair Labor Standards Act. Even somebody who absolutely specializes and does nothing but FLSA cases doesn't know all 200 exemptions.
Yeah.
So my instinct is if she does service, she's probably entitled to the wages. But I would have to do a little bit more looking at the Department of Labor and their fact sheets.
But if her bookkeepers send out an invoice and say the customer doesn't pay it for 2 months, does that mean she's not paid for that job for 2 months?
She's entitled. She may be entitled to wages, but she may not be entitled to those commissions.
Gotcha.
Because that's a contractual arrangement.
Wow. Okay.
There's no federal or state law on commissions, except how they impact, overall wages under federal law.
Yeah.
So finishing up sort of this little story, so I argue in front of the judge that this has happened so many times that it's now appropriate to issue the death sanction, strike his client's pleadings, enter judgment in favor of my clients. So he turns to the attorney, I'm not going to mention names, and says, what's your explanation for, all these motions, all these sanctions, and continued disregard of the court's orders? And he says, Judge, to be honest, every time I get a letter from Mr. Address, I pull a bottle out of my desk drawer.
Oh, man.
I'm serious. That was what he said to the federal judge, that my letters so shook him that he had to drink. And the judge, instead of striking his client's pleadings, ordered him to call the Florida Bar Assistance Hotline to get help.
Are you serious?
No, I'm very serious.
Whoa.
And to submit an affidavit that he had done so. Also ordered him to hire other counsel as co-counsel in the case so that I could communicate with them and not him, so that I had somebody reliable to deal with. And that's how the federal judge chose to handle that particular issue. But, Cliff was right. Sometimes my letters have an impact.
Stuart the Terminator. Whoa.
Now, Cliff also mentioned sexual harassment. And I have to say, and I mean this, the double-edged sword here. In all sincerity, all the sexual harassment calls and cases we get are abhorrent. There really is no excuse for it anymore. There's no excuse that people don't realize you can't do these types of things. Unless you're living under a rock in Ukraine, you've got to understand that this is wrong. But that being said, they're my favorite cases because they tend to settle quickly. So, for example, if a boss decides to send a text message to an employee with a photograph of his expletive deleted.
Yep.
I don't know if I'm allowed to say the word on radio, even if it's a technical and anatomical word.
Thank you, Matt Lauer.
I heard a lot on cable the other day. Anyway, but the picture of his expletive deleted. When I send my demand letter, one page of that demand letter is an 8.5 by 11 color copy of his expletive deleted.
Oh, come on. Are you serious?
Yes, I'm very serious.
Oh, God.
And in one recent letter I wrote, if you were going to send this type of a text, you at least could have made it impressive.
Oh,
it was small and it wasn't very impressive. So I figured, give him a color copy of it, embarrass him, ridicule him a little bit, and suggest that perhaps nobody else might want to know about all this, because if we have to file suit, we'll be doing a press conference.
with video.
Well, those pictures will be available for all the media. That case did settle within like 2 weeks for a very nice amount.
Wow.
So, Cliff is correct. Sometimes my letters can have an impact. They don't always. And on sexual harassment, I enjoy the demand letter process, even if it is the fact situation is often, always traumatic to the client. But my goal is to take that traumatic event and maximize what they can recover. And so, my goal with them is to be sympathetic, but when I'm dealing with the other people is to be a jerk. That's a polite word for expletive deleted.
Yeah.
Let's just say the first word is something and the second word is whole.
Yeah, yes.
And I enjoy being that when it comes to some of these cases.
It was interesting. I was listening to Fox and Friends the other day over on WSTU, and they brought up the whole sexual harassment thing, and they were talking about some employees that like to hug.
Right.
And they just said, no.
Right.
You cannot.
An anti-hugging policy.
Yeah. They just said, of course.
The problem is we are in a very politically correct culture right now.
Yes. Yeah.
That is not necessarily a bad thing, but as with everything, it can be overdone.
Yeah.
Now, I can understand an employer having an anti-hugging policy. In fact, if I was representing an employer and giving advice, I might even suggest that for the company handbook. But I think it's silly, because to be sexual harassment, the activity has to be offensive. Okay? If you hug somebody and you're told the first time, I don't appreciate that, and you don't do it again, there is no sexual harassment under the definition of the law. It doesn't happen the first time. You have to have at least 2 instances separated by some period of time. So if I hug you and you say, please don't do that, and next week I do it again, now you may have a sexual harassment claim. But that first hug, because that's not is sort of free. Now, we can do a lot more obscene things one time. What do you do with those? You have a problem proving sexual harassment, because you have Supreme Court precedent that talks about at least 2 instances. So there, if human resources won't do anything, you may have a battery claim against the individual who engaged in whatever conduct, but you may not have a sexual harassment claim against the employer.
They were getting into, and I know this pretty well because it happened at ESPN a couple times, where there could be a female PA going with the cameraman and myself. And so there was a situation in Kansas City where they only had one room. Well, we're sleeping on the floor. But, that could be a strange situation, obviously.
Well, yeah, that's a strange situation, but not necessarily sexual harassment. I mean, not everything is sexual harassment.
Right. No, I get that.
If you all have one room, let's say you get assigned, to cover a story in Kandahar, and the only thing you can get is one room. Well, it's not.
Maybe without a roof.
Yeah, it's not sexual harassment to have all of you sleeping in one room as long as you observe a certain basic respect of each other. Typically that means of the woman, but really it can mean of the man too, in this day and age. Then you don't have sexual harassment. Sexual harassment has to be something that is viewed as offensive, it's communicated as offensive. You don't stop. You complain to, depends on what kind of a company. A higher up, a higher supervisor, a manager, human resources if there's a human resources department. And then as we've discussed on other shows, they have a duty to investigate, and if they find the facts to be with merit, to take prompt remedial action. But, Joe Biden got in trouble recently, not recently, but for hugging.
A hug, yeah.
That's been his style his entire career.
I was going to say
he
that.
hugs, he pats on the back, he puts his hand on your shoulder. It's his way of communicating with the people. And as he began his campaign, this time around for president, he was advised that you can't do that anymore, Joe. We're in a different age, and there are people who have said they were offended by it, but they didn't know how to deal with it back then. People know how to deal with it now. People are more upfront about saying they're offended, and you can't just go hug a woman because you feel like saying hello, even if you don't mean anything by it. Now, honestly, I think that's a shame, because if you're trying to make a connection and you're giving an innocent hug, if somebody says, please no, all right, then you back off. But not everybody finds that offensive. Some people would find that endearing. I saw, for example, I'm going to tell you, last night, I was watching on DVR an episode of Madam Secretary.
Mm-hmm.
Now, she is now
we watch that all the time.
President of the United States.
Right.
Obviously the last season if she's now president. All right, and they're showing flashbacks to her campaign. And she's doing a town hall, and somebody is telling a story about how they lost their house.
Yep.
And, the husband died because he couldn't get medication. And it was a very touching story. So she goes over to the woman, and she gives her a bear hug.
Yeah, it was a lengthy hug, yeah.
Now, let's say it was not Madam Secretary, Madam President, but Mr. Campaign, Mr. Biden. And he goes over and gives that woman a big bear hug. Do you really think he's doing anything wrong, or is he showing compassion? Now, if that woman didn't like that hug, she has every right to say so and ask him to please move back. Okay, and that could be a little embarrassing, but she has every right. But, to say no hugging or anything, I think takes things a little bit too far. You should have the right to say you find something offensive, and you should have the right to be respected when you say it. But to say that people, there are some families that are huggers.
Yeah. Oh, yeah.
Okay, there are some people that are huggers.
Italians.
Okay?
Yeah.
To say to them, stop it completely.
Yeah.
I think that's overboard, overkill. It's too PC.
What they were talking about on Fox, and it's a very interesting thing, the producer was Muslim, and she was offended when the reporter and the camera guy just took their shirts off.
And I can understand that.
And oh yeah, well, and that wound up in the legal system.
But it shouldn't have wound up in the legal system. If she was offended and she said so, and they put their shirts back on or they got changed in the bathroom or what have you, that should have been the end of it. Now, if they laughed and they made a joke about it and they did it again, then yeah, she has every right to have a legal claim. Mm-hmm. I mean, look, I handle all types of discrimination claims. I handle sexual harassment fairly often, unfortunately. I mean, it's profitable, but unfortunately still keeps me in business. But not everything is sexual harassment. There are a number of calls that we get where when we get the facts, we have to gently explain unfortunately, as the law defines it, that's not sexual harassment. Now, that doesn't mean you don't have other claims. You could have an assault claim if the person threatened to touch you. You could have a battery claim if he touched you. If he held you against your will against the wall, that's false imprisonment.
Wait a minute. You could get nailed for assault
Yes.
if it was verbal?
That is what an assault is, actually. An assault is the
I thought
threat.
you had to have physical
No, that's
contact.
battery.
Okay, there you go.
That's why
Okay.
they say assault and battery.
Gotcha.
Assault
Yep.
is the threat, battery is the offensive touching.
Gotcha. Okay.
And if you hold somebody against the wall and don't let them go, even for 30 seconds, that's false imprisonment. These are torts. So you may still have tort claims against the individual who did this to you, even if you don't have a claim against the employer. And very often, if it's under 15 employees, where Title VII of the Civil Rights Act and the Florida Civil Rights Act don't cover you, then what you're really left with are those types of tort claims.
That's civil?
That's civil.
Okay.
I mean, depending upon what's done to you, I guess it could be criminal too. But those are civil claims. Those are the things I handle. So. At least we didn't get diverted on politics. We got diverted on other things.
Well,
Because I could say so much about politics.
Yeah, you don't even want to go there this week.
I mean, the briefing that was given yesterday.
What's happened in the last hour? I don't know. Things are changing.
Are the Yankees
so
in the
fast.
World Series? I don't know.
No. It's going to be the Astros.
Talk about anything. Yeah,
This
that's
is
fine with me. Anything but the Yankees.
This is going to be an all Palm Beach World Series.
Isn't that interesting?
If the Astros win, the Nats and the Astros train at that new
That's
park
right.
in Palm Beach. Hey,
right.
good for business.
I guess
here.
that must be good grass there.
It's going to be good for the Mets. yeah.
All right. So, I was going to talk. We have a little bit of time left.
Oh, you got plenty of time.
Yeah.
You got 20 minutes.
I was going to go back to a topic we had discussed about a year and a half ago. Because just this week in my office, I think we've had 4 or 5 calls. We've actually had 2 or 3 people come in for consultations. And I had calls last week on it too. So it's again going on. It's like things come in ebbs and flows. These are non-competition agreements. You're an employee, you sign a non-compete.
Yep.
And I think when I last spoke about this, I concluded the discussion, which I'll begin the discussion this time, with the moral of the story. Don't sign a non-compete until you show it to a lawyer. You are risking your future opportunities to work, whether you quit later or you get fired. Be very, very careful when asked to sign a non-compete. Yeah.
If they fire you, it's irrelevant.
Well, if they fire you, it's not irrelevant. If they fire you, it's fully enforceable. A non-compete is enforceable no matter what the reason for separation. Now, there are some non-competes that are written that if you separate voluntarily, the non-compete is this, and if you're terminated for cause, the non-compete is this, and if you're terminated without cause, the non-compete is this. I mean, those may be much larger companies, corporations that get into a little bit more detail. But generally, what I see is non-compete, 2 years, all of Florida, all of the United States, all of the world. That's what I see.
But they can't stop you from working.
Yes, they can. That is what a non-compete is. So let me tell you, under Statute 542.335 of Florida statutes, enforcement of contracts that restrict or prohibit competition during or after the term of restrictive covenants, so long as the contracts are reasonable in time, area, and line of business, is not prohibited. Now, it's interesting. They say it's not prohibited. I'll tell you something else. When you read the cases, it goes beyond not prohibited. They're favored. Courts will seek to enforce them. And in fact, if you go back down to 542.335, 1C, lawyers love little subparagraphs. It says, 1 second. Let me find the one little bold. Oh, I'm sorry. It's not. It's 542.335 1G1. That's 542.335 1G1. Bingo. Now, it says, in determining the enforceability of a restrictive covenant, a court shall not consider any individualized economic or other hardship that might be caused to the person against whom the enforcement is sought. So, don't think you're going to sign a non-compete, and then when they try to enforce it against you, you're going to go to court and argue, Judge, this prevents me from earning a living. This prevents me from paying the mortgage. This prevents me from feeding my children. This prevents me from paying my child support obligations. Not only doesn't the court care, but by statute, it can't even listen to you. It will not listen to that argument. It doesn't matter.
Wow.
What matters is very simple. Complex in resolving it sometimes, but very, very simple. What matters is it reasonable in duration, time? Is it reasonable in scope, geographic? And is it necessary to protect the business? That's all that matters. And unlike other contracts, this is a special situation where the courts can rewrite the contract. In another contract, if you say, and you're going to pay me $250,000, and let's say the law says you can only pay $200,000. Well, they don't then change it to 200. The contract is void. It fails. Court can't rewrite it. Non-competition provisions, agreements, whatever, clauses, they're different. Don't ask me why. I guess it comes out of the English common law. They can blue pencil them. The statute says they can blue pencil them. The case law says they can blue pencil them. The court can change the duration. The court can change the geographic scope. But it cannot say, I'm not going to enforce it because it hurts you too much. Tough luck, you signed it.
All right. Say, okay, you talk about geographic scope. What if it's, say, a national company like a GM or a GE or something like that?
I had a client in my office this week. It said, the world.
Oh, come on.
That is sometimes enforceable. What you have to look at in those situations is, A, is this truly an international company that does business virtually everywhere? B, what were you doing for them? If your only business was the Southern District of Florida territory, no, the world is overbroad geographically, and a court will likely blue pencil it to the Southern District of Florida territory in which you worked.
Okay, that makes sense.
On the other hand, if you are the vice president of business development and you travel 10 months out of the year all over the world, that non-compete is going to bind you against competing against them for a reasonable duration all across the world.
Wow.
So lawyers now then, when we get these calls, we say, first of all, I need to see the non-compete.
Sure.
Telling me about it is nice, but I need to see it. I need to see how the words read. Because as lawyers, we're also trained to look at where's the comma placed. I know that sounds ridiculous, but sometimes a comma means a continuous sequence of examples, and sometimes the comma says what follows a comma does not apply to what preceded the comma. And there is case law that there's Supreme Court. There are Supreme Court cases that talk about where the comma was. It can be important.
Wow.
That's why when a lawyer says, I can tell you this from your description, but I need to see the document. We're not play acting. We need to read the agreement. It's one of the things we get trained in, hopefully very well. Now, if you have a non-compete, you show me a non-compete, I'm going to look at the duration, I'm going to look at the geographic scope. I'm going to look to see, is there a legitimate business purpose? And usually there is. I'm also going to look to see, what do you do? What did you do? What was your scope of work? Where did you work from? Where did you, did you make phone calls to Idaho? Tell me all about your job. And then I can give an educated analysis of, well, I think the duration is fine, but the scope is overbroad. I think the court would probably blue pencil that. Maybe we should write a letter demanding that, they narrow it. Whatever, there's lots of options. But if I tell you, as I've had to tell some people, the duration is legitimate under the law, the scope, geographic scope is more than reasonable, there's definitely a business interest here, I can say to you, you might not want to waste any more money on me, because you're going to be bound. The only thing I would say in that instance, and I always do, is go get a second opinion, because there are lawyers that will disagree with other lawyers, and this is my analysis, and if my analysis is contrary to your interests, go get a second opinion. Make sure somebody else agrees with me. And then maybe you give it up, but don't just live on what I tell you, because, what I say isn't the gospel.
So you could be forced to say, move to Idaho.
Yes. Yes.
Wow.
And you could have a house on in Sewell's Point in your family for 120 years, and now all of a sudden you can't work. You either have enough money to live there until the non-compete's up, go do something different that doesn't violate the non-compete, in which case I might be able to say to you, look, the non-compete, I had an example like that this week, and I won't be too specific because it's not fair to the client. But I had an example where the non-compete said, you cannot work within 10 miles of this type of a project that we, the employer, are engaged in, anywhere in the country. This type of a project, you can't be anywhere within 10 miles of it.
Whoa.
But it was reasonable because the type of project in the non-compete was so narrowly limited that when I discussed it with what do you do, there were so many other things in that industry he can go get a job in and still not violate the non-compete. And he already had a proposed opportunity, which he asked me, would that violate the non-compete? I said, no, not the way the non-compete's written. So go with God. Go take that new job and enjoy. Good luck. And if you get a nasty letter, let me know because I think they're wrong. Doesn't mean you won't get a nasty letter. Everybody can sue everybody for everything in this country. But my analysis was, it's okay. The non-compete is okay, or in terms of what you can do. So when you're looking at these non-competes, the court is going to give a lot of deference to the employer. Now, there are non-competes that deal with former employees. There are non-competes that deal with former owners. And there are non-competes that deal with former independent contractors, distributors, things like that.
Yeah, I think we know a fellow who used to own a restaurant, and there was a deal there that he couldn't open up a restaurant in the city of Stuart, as a matter of fact.
Right. So, for example, the normal situation that I encounter, former employee. The law says that the court shall presume. This is against the employee. This is the independent former employee. Yeah, former employee. The court shall presume reasonable in time any restraint 6 months or less. There's a presumption of reasonableness there, 6 months or less, and shall presume unreasonable any restraint more than 2 years. Now, what's that mean? If it's 5 months, it's presumed reasonable, but you can show, if you have the facts, that it's unreasonable under the circumstances. Not because of how it affects you, but there could be circumstances that make it unreasonable. If it's more than 2 years, I make it reasonable. If it's more than 2 years, it's presumed unreasonable. But an employer can show, for whatever reason, it really is reasonable. But those are the presumptions. Between 6 months and 2 years, there is no presumption. It just is what it is. And either side can argue before the court that it's not fair for a variety of reasons. Now, I had a guy at a shoe store once, big company, but he only worked in one store in Stuart, and they wanted to prohibit him from working in like the Tri-County area. I told him, no. Based upon the case law that I've reviewed, it is likely a court would not enforce that. There is no legitimate business interest in taking a typical shoe salesman and saying you can't go from Martin County to Okeechobee County.
Yeah,
and that was my advice.
Yeah, they're not competitors.
Right. So if you are dealing with a former distributor, a dealer, a franchisee, a licensee, then the presumption is less than 1 year is reasonable. More than 3 years is presumed unreasonable. And then when you're dealing with a former seller of all or part of a company, somebody who's selling you the assets or the company, then the court will presume reasonable anything under 3 years and unreasonable anything over 7 years.
Wow.
Because if you're selling your business,
yeah,
that new owner really has a right to expect you're not going to go out and start competing.
Yeah.
If there's a non-competition agreement. If there isn't, then do what you want. Okay? So, what I'm really saying, to everybody who's listening is, and we didn't go through everything in the non-compete, but we hit the highlights. When you're talking about a non-competition agreement or a separate clause in an employment agreement or a provision in an employment agreement, or you've been working there for a day, 6 months, 10 years, and all of a sudden they give you, we're making all our employees sign this, you need to sign this or you can no longer work here. That's legitimate. Perfectly okay. But I really suggest that you take that non-competition document to a lawyer, because what you don't want to happen is that you sign it, they fire you the next day. They were just waiting, laying in wait for you. And now you look at it, and if you want to work, you've got to travel, let's say, at least 100 miles. And let's say, under the circumstances, that's going to be enforceable. Well, then you've got to travel at least 100 miles.
Yeah, we ran into that a lot in television, especially in Southern California, where,
where going 10 miles takes 2 hours.
Well, yeah. But, I mean, where, you would be, if you were in, say, an anchor in San Diego, that they would say you can go to L.A. or San Francisco, but, yeah, you're persona non grata here.
Right, and it all depends upon what you're doing, what kind of a company you're dealing with. What is reasonable and not reasonable changes. And that's why you need a lawyer to help you interpret it, not just to read the document, but then to question you with the right questions as to what did you do? Where did you do it? What's the purpose of your work? To say to you, well, under the circumstances, this part of the agreement's reasonable, this is unreasonable, the whole agreement's reasonable, the whole agreement's unreasonable, and to give you advice so that you can make a decision what to do. Very often, what I will encounter is this. Somebody has a non-compete. They leave a company or they're fired. They go get another job, and they get a demand letter from a lawyer. But it's not just they that get the demand letter. It's they and their new employer. And that's to intimidate the new employer who, unless you're really important to them, doesn't want to have to be embroiled in litigation and paying legal fees just for you. Now, if you're their new CEO, maybe they'll stand behind you and, pay some money in legal fees because they want you. But if you're a fungible commodity, you're not going to have that new employer stand behind you. You're going to be out of another job. So ask a lawyer before you sign a non-compete agreement. Really, it's important. It's important. A lot of people have come to me, and there's nothing I can do. And then there are a lot of people that come to me, and there's plenty I could do. But these things are serious. They are enforceable. The court favors them. And if you're going to sign one, you better realize that it could have some very serious consequences to you and your family. So be aware. Buyer beware. Signer beware. Employee beware.
I'm glad I'm fungible.
Fungible, yeah. Well, station owner, I don't know how fungible you are, but then again...
My wife is a station owner.
You're not going to... Well, she could fire you then. Because you're not going to fire yourself. So as we sort of wind down, let me tell you that I mentioned a week before last, Lincoln Park Academy went to their first tournament of the year.
Yeah.
And we had somebody doing extemporaneous speaking and my son doing Lincoln Douglas debate. Both events are difficult and take a lot of research and dedication and nerves. But my son has actually been accepted to a very special tournament November 1st to 3rd. He was on a wait list and just got in. At the University of Florida.
Ooh.
Called the Blue Key Invitational. It is a national championship qualifying tournament where there are going to be approximately 700 competitors from 10 states. In his Lincoln Douglas category, there are 130 competitors.
Wow.
Over 3 days. So he'll get a lot of great experience going up against national caliber people. And hopefully when he comes back here to our local tournaments, he'll be able to kick some you-know-what. Anyway, that's all for Ask a Lawyer this Friday. I hope you have a great weekend and a good week. And if you need a lawyer, give us a call here or give me or Sadia a call at the office, 781-8003. Music's playing even louder now, so goodbye and have a great weekend.
You can hear Ask a Lawyer right here on WPSL, Port St. Lucie, WPSL.com, webcaster to the world, on Alexa and Google Home.